Hey everyone, welcome to this We and Law Explainer. Today we're diving deep into something I know a lot of you have been waiting for, a comprehensive, granular breakdown of the Nigerian Bar Association's brand new guidelines for the use of artificial intelligence. If you've been sitting there wondering, how on earth do I actually use AI in my daily practice without crossing some ethical line? Well, you're in the exact right place. Let's get into it. Look, we all know the rapid transformation of the legal landscape by AI is totally unavoidable at this point. But thanks to this initiative by the NBA's section on legal practice, we aren't just left in the dark to figure it all out alone. Think of these guidelines as your definitive, authoritative map for this crazy new terrain. They're here to make sure that as we adopt all this cool new tech, we're still upholding the profound integrity of the Nigerian legal profession. All right, so here is our agenda for today. We're breaking this down into 6 core pillars: AI and legal practice, navigating ethical obligations, data privacy and NDPA, rules for generative AI, tool selection and risks, and finally, embracing the future. Okay, Section 1, AI and legal practice. And hey, quick reminder to subscribe to We in Law. So to kick things off, we really need to define what we're actually dealing with here. The guidelines define AI as tools designed to mimic human cognitive functions. We're talking about things like machine learning algorithms that crunch massive amounts of data without being explicitly programmed, and natural language processing that can actually, interpret human language. But the absolute key takeaway here, and they stress this heavily, is that these systems are built to augment your human expertise, definitely not replace it. Now, how does this actually play out in the Nigerian legal sector today? Because this isn't just theory anymore. We're talking about using these tools to rip through vast databases of Nigerian case law to find binding precedents. It's about automating those really tedious contract reviews to flag inconsistencies, speeding up e-discovery, and get this, even using predictive analytics to forecast litigation outcomes and optimize settlement strategies. It's literally meant to do the heavy lifting for you. Moving on to Section 2, navigating ethical obligations. Remember to subscribe to We in Law. Now, the guidelines make this crystal clear. Just because you're being innovative doesn't mean you get a free pass on ethics. The use of literally any AI tool has to be completely and strictly aligned with the ethical standards set by the Rules of Professional Conduct for Legal Practitioners 2023. You simply cannot separate the tech from the rules. Let's map out the first half of this crucial ethical crosswalk. And guys, these aren't just compliance checkboxes. They're essentially the shields protecting your practice. For example, if you just go and feed sensitive client data into a public AI tool to help draft a brief, you've just severely compromised Rule 19 on confidentiality. Plus, Rule 16 on competence means you have to actually understand the limitations of the AI you're using to avoid making huge errors. And blind trust in AI outputs, that directly violates the Rule 14 duty of care you owe to your clients. You have to stay diligent. Continuing this crosswalk, let's look at Rule 24, your independent professional judgment. You can't just outsource that to a machine. And even more pressing is Rule 15. Since AI has the capacity to generate or alter evidence, think false images or voice deepfakes, you have a strict duty not to create or preserve false evidence. Also, we all know AI tends to hallucinate or just make things up. If you're not careful, that could lead to publishing misleading advertising, which completely runs afoul of Rule 39. All right, Section 3, data privacy and NDPA. Subscribe to We in Law. You always have to remember that data is the absolute lifeblood of AI systems. Because data is what powers these tools, legal professionals using them have to comply strictly with the Nigeria Data Protection Act, the NDPA of 2023. This is just to ensure absolute lawfulness, fairness, and transparency anytime you process data through an AI platform. So, to actually maintain this mandated confidentiality, law firms have to follow some very deliberate practical steps. First up, you need informed client consent before you run their data through an AI. Second and third, you've got to employ strong encryption and strict access controls. Basically, only the people who absolutely need to see the data should be seeing it. And step 4 is huge. Never, ever enter sensitive client information into unsecure platforms. And yes, this specifically includes those everyday tools you might not even think twice about, like unsecure AI meeting transcribers or random translation apps. Next up, Section 4, rules for generative AI. And don't forget to subscribe to We in Law. So generative AI, things like ChatGPT or Claude, is kind of a unique beast, and it comes with very strict rules of the road. Take a look at what you must do. You absolutely have to critically review every single piece of output for factual accuracy and legal soundness. You've also got to proactively supervise junior staff so they aren't just taking lazy shortcuts with AI. On the flip side, the don'ts are just as critical. You cannot blindly rely on AI for legal judgment, and you really must avoid uninformed usage where you don't even fully grasp the limitations of the tool you're playing with. Section 5, Tools Selection and Risks. Subscribe to We in Law. Now, when it comes time to actually pick an AI vendor for your firm, please do not get swayed by flashy marketing and hype. Instead, you need to rigorously evaluate the tool against these specific criteria. Ask yourself, does it actually align with our specific legal workflows? Is it NDPA compliant? And one massive thing to look for here is explainable AI, or XAI. You have to demand transparency from your vendors so you can actually explain the reasoning behind the AI's recommendations, whether that's to a client or, to a judge. The thing about AI is, it is definitely not a set-it-and-forget-it kind of technology. You have to proactively conduct regular algorithmic bias testing, mainly because AI can easily inherit prejudiced data. Plus, you need to continuously monitor the tool's performance while executing ongoing data security audits. This is the only way to prevent discriminatory outcomes and nasty data leaks. Finally, Section 6. Embracing the future. Subscribe to We in Law. I want to highlight this really powerful quote from MBA President Yakubu Chinoko Maikio because it just perfectly summarizes the mandate for the Nigerian legal sector. AI presents this massive opportunity, right? But that opportunity is only valid if we remember it's an augmentation tool. It is not, and honestly will never be, a replacement for the seasoned ethical judgment and critical thinking of a real legal practitioner. With the official signatures and endorsement of the NBA leadership and the section on legal practice, these guidelines are establishing a vital new culture for our profession. It's a culture of forward-thinking innovation, but it's inextricably intertwined with profound professional responsibility. So, as we wrap up this We and Law Explainer, take a hard look at your own firm and your own daily habits. Is your legal practice truly ready to harness the incredible power of AI while flawlessly upholding the ethical and regulatory obligations you swore to maintain? It is a tricky balance, but one we all have to strike. Thank you so much for watching, and we will catch